All right, in this second clip, okay, we're gonna see how uh, media freedom or freedom of expression or freedom of the press conflict with the privacy. Okay, now we know both interests are protected under the law. See, so freedom of expression and freedom of the press are protected in order to serve the public interest, right? Because as the gatekeeper, as the watchdog, whatever, they have the freedom, right, to report the news, report the facts uh, that the public are supposed to know, right? What's going on in your in our community, in our society, and what and like as the more the information that people have, the more people are gonna make the decision more accurately, right? So when there is the conflict between them, so we need that careful assessment which interest, either like freedom of the press, either the privacy, the right to privacy, would prevail in that case. And of course, there is no exact formula, or there is no like instant formula that we're gonna decide this is prevailing, this is more interesting, okay, over another one. So in terms of like conflict, when two values or interests are conflicting, of course we need careful assessment. We need to see if which privacy cross the line, because like the scope or the idea or the concept that you have learned from the constitution is that the exercise of the right freedom cannot be in the manner that would violate the right of freedom of the others, right? But now we are in the situation when the exercise of the rights and freedom would have an impact on others, but we need to know which one prevailing. Okay, so it's a little bit more difficult than just say, okay, the exercise of this right will not have any impact or will not affect somebody else's rights, right? But now it's affecting. However, if that effect is acceptable under the law, right, we need careful assessment. Okay, again, from this slide, when two values or interests are conflicting, so we need to decide whether the right to be let alone. Yeah, in the media, I mean, in the context of the conflict of the media, freedom and the privacy right, the right to privacy that we kind of like focus on is the right to be let alone that Warren and Brenda explain in their article as the right of a person, okay, to be away from public attention, right? To be in the news, you are going to be not going to be a public figure necessarily, but you will be in the public attention. So most of the people, if they see the news, they're gonna know you, what happened with your lives. They don't care like whether that would be private or non-private lives, but yeah, this information will be exposed to the public. Okay, and the media as the medium, okay, they enjoy the freedom of the press, they have the right to freedom of the press, and if that news is okay to be known by the public, okay, is not going to violate the right of privacy. Okay, so we don't know exactly where the line between these located, but at least we have some ideas or thoughts on that, how to do the assessment carefully. Okay, so from this picture, yep, if you are an individual and sometimes you are not willing to be in the spotlight, right? You are sometimes you feel uncomfortable to be in the spotlight where people can get access to your lives, right? They know what happened with you, with your family. You might not be happy with that, but sometimes you need to sacrifice your privacy in order to serve the public interest. That would be like the common case that we see. For example, the public figure, right? They are known by the most people in the society, and the story or any information about them, even regarding their private lives. So it might be okay for the media, okay, to have that in the news or put some information in there, as long as it serves public interest, right? Serves the public right to know what happened in the society, right? For example, the prime minister, okay, when he like go to some provinces to take an action on the flood problem or any kind of problem, okay, the PM, the prime minister, went to this to invest to do the investigation, to do the survey or explore or visiting the site, okay, of the project, something like that, okay. Can the prime minister say, okay, this is my private matter, this is my private lives, and can he like prohibit the news reporter to report the news about the prime minister in that area? The answer is pretty clear, okay, right? That the prime minister cannot prohibit the news or the media like to report the news about his affair on like his, I mean, his job, right? As the prime minister, he is supposed to do something in order to solve the problem out in our country. And wherever he goes, he try to tackle some problems in some provinces, and people are supposed to know what happened, right? So as the elector, as the citizens who have the right to election, right? So you know, okay, next time in the next election, are you going to choose this person, right, to be prime minister or to be our representative? So you have some information to make decision, and this is enough. Okay, this is enough to say that okay, the right privacy or as some to some extent of a person will be sacrificed because he hold the official position, right? And his job, okay, his action, okay, are supposed to be known by the public. Okay, so the news, you can put that in the news article, you can put that in the news report. Okay, even they have an impact at some point to the privacy of that person, but that is acceptable under the law. So in that case, which one prevail? Yes, media freedom, which serves public interest at the end of the day, right? Not the privacy of the prime minister, especially when we deal with the situation or the when we deal with the his action on duty in his office, right? His official position, right? The action as the prime minister, not something like family activities or something really private in his private home, for example. Okay. So, but still, the lie remain unclear all the time. Sometimes we need to look at the context of the situation, okay, when the right to privacy and freedom of press are conflicting to each other. Okay, we have to look at the context. We have to look at the action of both parties. Okay, is it too much? Is it offensive? Is it in the manner that would have an impact a little bit less than they do in the news or not? Any less intrusive matter? Any less offensive manner possible? Is it possible? Might be the activities of the media might violate the private lives, like the privacy of that person, possibly. Okay. So the right to privacy is protected under Thai law in section 32 of the current constitution. You know, like how many constitutions we have, right? So many versions. But for the current version in the Constitution of Kingdom of Thailand, section 32 say a person shall enjoy the right to privacy, dignity, reputation, and family. Okay, so the right to privacy here has the broad meaning. Okay, we have learned from the previous clip already that privacy is a broad concept, right? That cover so many aspects. Okay, but one aspect that we are interested in is the aspect mentioned in the article written by Warren and Brandeis. Okay, aka right to be let alone. Okay, right to be let alone, right to be away from the media or public attention. Okay, not to be in news, something like that. So let's take a look again on the section regarding freedom of expression. We have seen this before. We have read this before when we talk about freedom of expression in general, like from the very first classes taught by Ajahn Ying, right? So, 34 says a person shall enjoy liberty to express opinion, make speeches, write, print, publicize, express, something like that. The restriction would be done by the provisions of the law. Okay, and yes, for the purpose of maintaining security, protecting the rights, liberty of other person, and again, right, the right to privacy, okay, has been provided by the Constitution, the same level, right? Another section, okay, is protected under the law as well. The right to privacy is protected under the law as well. See, so yeah, again, the conflict again, right? What if the freedom of expression had been exercised in the manner that would be that would constitute violation of the right to privacy as protected by Section 32? Same thing, right? When there's a conflict, we need the assessment, and we have to decide. We have to make a decision which one prevails. Again, media freedom of the press has been emphasized in Section 35. Okay, I'm not going to read it again because you can see and the lie. We don't exactly know where the lie is, but at least we have a list of criteria. It could be core criteria, or we have something to think about, okay, to do the assessment. All right, and what kind of assessment that we're gonna see? First of all, we don't know exactly where the line is, but at least we know who draws the line, okay? Because from the provision from the sections that we've seen, okay, there is just the general concept on how to how those two interests could be in the conflicting manner, right? So if there is a conflict, I mean, if there is the case, the real case, okay, a dispute between like media agencies and individual who are who is mentioned in the news, okay, whose information is published in the news. The case between these two parties will be decided by the court, okay? So the court would consider and draw the line in that case and will consider whether whether freedom of expression can prevail or not, okay? So at least we know the court has the role like to draw the line between these two conflicting interests. But in Thailand, unfortunately, we don't have so many like cases to see. That's why in the part that you're going to present your cases, that would help you to understand more about the concept when we comes to the conflict between freedom of the expression and the right to privacy. Okay, in Thailand, it doesn't mean we don't have any case. We have one case so far that I have found from the database of the Supreme Court cases, and I'll show you later. But at least, you know, the person who draw the line, who decide the case, right, is the court, Thailand. And here I intentionally, if you see this circle, this picture, you can see that the area of the freedom of the press is a little bit bigger. So from my experience, like seeing a lot of cases, most of the time, I mean, most cases, maybe like 70-80%, freedom of the press prevails. Why? Because, you know, freedom of the press serves public interest, and yeah, again, privacy might be sacrificed in order to serve that public interest. Okay? And now we're gonna find more clues on how on where that line is located between them. Okay. So what does the line look like? It should be. I mean, there are so many cases, but this is the list of cases I think are interesting, and some of the cases are assigned to you already. Okay, for some case I would skip and leave it to the group that gonna present that case to be the presenter. Okay, so I'm not gonna mention that too much to make sure to leave some room for the group working for the group presentation. So what does the line look like? These are some cases which are interesting. First of all, we refer so many times to the article written by Warren Brandeis, and he explained that the right to privacy, or sometimes he called right to life or right to be let alone, it is the right that should be protected. So in Warren and Brandeis are American. Okay, they are American. So this article has been written in the context of, I would say, like American law, American legal system, where the legal system is common law, as you know. Sometimes the court must develop their own principle, like legal principle, to be applied in the case, right? And this article has been cited in the court decision so many times. Okay, I would say that uncountably cited by the court decision. They refer to this article all the time when they talk about privacy. Okay. So what he wrote there, they said we must therefore conclude that the rights so protected, whatever the exact nature, are not rights arising from contract or from special trust, but are rights as against the world. And as above stated, the principle which has been applied to protect these rights in reality, not the principle of private property, right? Unless that word be used in an extended and unusual sense, the principle which protects personal writings and any other production of the intellect of or the emotions is the right to privacy. So he talks about the intangible like nature of the right to privacy, okay, apart from the physical aspects of that. Because before that, the oldest kind of privacy is the right at home, right? Which is linked to the physical property, okay? Like the private area, like the real space, something like that. But now it is extended to be more like intangible. But we don't forget the physical aspects of that as well. And the law has no new principle to formulate when it extends to this protection to personal appearance, saying acts to personal relation, domestic or otherwise. So you can see some sense of like intangible interest protected by the law. Okay? And yes, it is the right to be let alone. So Warren and Brandeis have some notes on this kind of right. He said that this kind of right is not absolute. It doesn't mean that this right cannot be accepted. Okay? There are some cases that this right should not be protected as well. For example, the publication of matter which is of public or general interest is okay. It doesn't count as the violation of this right. Of course, again, we believe in this situation that the public interest prevail, right? And the public interest has been facilitated by the media freedom, right? So next is sometimes if that individual kind of give consent to the media, okay, that his or her story will be published in the news, something like that. That's okay. That's okay. It could be waived. Okay. Or the truth of the matter published does not afford the defense. So if you publish something really private and it's kind of violating the right to privacy of the others, we don't care. Even we don't care whether what is published true or false. Even if it is true, it could lead to the liability. Okay. So the case between the media free the case on the conflict of the media freedom and right to privacy is normally in the form of tort claim. Okay, in the tort claim, the idea about tort, you have already learned that the tort is the situation that somebody, right, hurt another person or causes a damage to another person, and therefore the tortfeasor is liable for that damage. Okay, so the this action by this news agency or by the media, like publication of somebody else fact in the news, could have a damage on the right to privacy of another person as well, and that would be in the form of what we call publicity given to private lives. This is the law in the US, and next we're gonna see that is really similar to what we have in Thailand. Okay. So publicity given to private life is said that one who gives publicity to a matter concerning the private lives of another is subject to liability, right? It's liable to the other for invasion of his privacy. If the matter publicized is of a kind that A, would be highly offensive to a reasonable person. Second, it's not of legitimate concern to the public. It's really important here that the liability here can arise, okay, only if the matter publicized is not of legitimate concern to the public. So even if regard the private lives, but it is of the legitimate concern to the public, it's a public interest, it's okay to be publicized. Okay, the person who publishes will not be subject to the liability. Okay, here. And one case that is pretty interesting is the case between William James Sidis versus FR Publishing Company, okay, corporation. It is a case between the publication corporation and the person in the news, which is Mr. Sidis. Mr. Sidis was a child prodigy. He was a genius. At the age of 11, he gave the lecture to the professors and also the graduate students at Harvard University. See how genius he is, right? However, after that, 20 years later, his personality has been shifted a little bit more. So he tried to escape from the public figure status that he had in the past. He tried to escape from like anyone who knows his background. So he got a job in a small shop, but if the shopkeeper, like the owner of that shop, find out that he was once a child prodigy, like who was so smart and like really genius one, he left the job. He left the job and moved to the new job. And the job he working for is just like a clerk, just regular job, which requires just regular skill, not like really extraordinary skill in math that he had before. Okay, that he had before. So he tried to escape from the position or the status in the past that he had. However, 20 years later, there is an article published by FR Publishing Company. Okay. Talking about his biography and his current life that he live in like the small apartment and work for the insignificant job, something like that. And they have like the cartoon draw with that article. It's just like 2-page article, but his biographical background has been provided and how he spent his life at the time is always portrayed as well. So after the publication of his information, right, especially the publication on how he is living right now, not right now, but at that time, okay, at that time, he was in the apartment. He worked for the job which is like insignificant. He sued the publishing company, the publishing corporation. However, he lose in the case, okay? He lose in the case because the court reasoning is that the publication of Siddhi's lives would provide a lesson to the public to learn from. So in the afterwards, the courts think that this is of a public concern. I mean, that have some public interest in there. Okay, even they publish something about the private lives of the person. Okay, that's okay. And the court reasoning, which is really interesting, is here. The court says certain public figures must sacrifice the privacy and expose at least parts of their lives to public scrutiny as the price of the power they attain. So the lesson that we learn from this case is not the result of the case, but the reasoning, right? As the public figure, right, you must sacrifice a part of your life, a part of privacy that you have as the price to pay when you obtain the power, like being a public figure. And like to be a public figure sometimes is not from your consent. Sometimes you are, I would say, unconsciously going to be a public figure. For example, like the kids of the celebrity, like the big family relating to celebrity, something like that. Sometimes they are transformed to be the public figure without any like intention or without any consent from that person. And even in this case, the Siddhis try to escape, right? He doesn't want to be the public figure anymore, but in the past, like 20 years already passed, the court still think that he was still the public figure. So that's the lesson we learned. At least public figure has a part of their life to be exposed to the public. But it doesn't mean like they have zero privacy, okay? So it's really, this case really this case could be an example on the scenario when these two interests are conflicting to each other. Okay? On finding the right balance, okay, it's challenging. Okay, it's pretty challenging, and we know the careful assessment, as I told you. From the quote here, it reminds us of how careful we should do. Especially, she emphasizing the role of the court, okay? To be more and more careful in order to do so. The right to privacy compete with the freedom of press as well as the interest of the public in the free dissemination of news and information. And these permanent public interests must be considered when placing the necessary limitations upon the right to privacy. Okay? She reminds that, okay, don't forget when we are going to limit the freedom of the press, Don't forget that freedom of the press serves the interests of the public in the free dissemination of information, right? Of the news and information. Don't forget that. Okay? The interest behind the freedom of the press. And if we're going to do the limitation on the freedom of the press because of the right to privacy, be careful, because an action based on the right to privacy must not become just a vehicle for establishment of the judicial censorship. However, on balancing the very interest is pretty tough though. So this is the quote that would remind the judges to be aware, to be more careful. Every time they limit the freedom of the press, it means that the interest behind, like public interest in free dissemination of news and information, will be affected all the time. Cause it should so the court must be careful if they're gonna limit the freedom of the press based on the right to privacy. Right? So Cox Broadcasting Corporation versus Cohn is the landmark case in the US where the Broadcasting Corporation obtained the name of the rape victim who is already dead and published that in the news. And the victim's father came to the court to sue this corporation. And the court said that this is okay because the Cox Broadcasting Corporation obtained the information from the public record, which is the court decision, which is published. It is publicly available. Anyone can access it. Okay. The case of Lillestenberg versus Norway would be another example, but I will leave this to one of the groups that I assigned this case, but at least it's the case between celebrities and the magazine. Okay. Peg and United Kingdom is another example because they publish the footage of the CCTV in the news article, but the scene that they publish is a scene that that Mr. Peck was trying to commit suicide by slashing his wrist. And the news article, the picture or the photos, the footage used in the article, they didn't do any masking on his face. So the people can know that this guy was trying to commit suicide by slashing his wrist. And the court decided that, in this case, his right to privacy has been violated by that action. Okay? Normally, when we take a look at privacy cases, the defenses that the news reporter or the media site would rest as the defense in the case that, okay, they have the legitimate purpose or legitimate interest to supporting freedom of expression, media freedom. First is the legitimate public interest. And the legitimate interest is pretty important because the freedom of the press is serving the public interest all the time, right? By principle. And the test that we call in this one is the newsworthiness test. What does it mean by newsworthy? So by, as you know that we don't have the exact line, right? Exact line where the line is located, but now we now finding the tools to be used in the assessment, okay? So in the newsworthiness test, the question is that the information that we publish in news, does it serve public interest? And does it prevail over the right to privacy? So we have to take a look at these questions as the guideline in order to decide whether privacy or media freedom should prevail. First, does the information relate to any matter, political, social, or other concern of community? If relate to political concern of the community, okay, this is likely that public interest or freedom of the press gonna prevail. What is the social value of publishing the information? Right, you know that publishing somebody private lives, it might have an impact on that person's life. But if it serves public interest is more important, right? So we have to look at the value, what we get from this kind of news. Does it create any social value? Do people learn or do people get any benefit from having this news published? If the answer is yes, it is likely that it is newsworthy. Next is how far this publication intrude into private lives of the subjects. How much we have to see the intrusiveness on that case, right? What is the subject status? If that person is public figure, okay, you've learned already that the public figure must sacrifice part of their lives, right, in order to be like the price to pay for the power they attain, right? This is subject voluntary, assume position of public notoriety. Is there a connection between the information disclosed and newsworthiness? So we have to look at these questions, try to answer, and then conclude what would be the result of the assessment, which one prevail. The next defense is the consent, or if that person say, yes, please publish my information, that's fine. That's totally fine. We don't care if that is of the public concern or not anymore. Even it is not newsworthy, but this information has been published based on the consent of that person, that's fine. Even that would relate it to his private lives. Okay? Or the public record, that public records mean the record that anybody is in this world can get access to. I mean, some information are publicly available or publicly accessible. So once the news agency obtain that information, because it's already published, why the news cannot publish it? Right. That would be another defense. So in Thai law, we have no clear concept of privacy intrusion, but that is the case. It's really similar to the case of CITES and if a publication, but the subject matter is different. And also the decision or the result of the case is different as well. So this is from the Supreme Court case. Okay, this number back in 2015. But at that time, Section 32 in the current version of Constitution has been provided in Section 34 of the Constitution applicable at that time. Okay, you know, we have so many constitutions. So the plaintiff is a politician with many positions like the dean of business school, the consultants of the minister of different ministries, board member of political party. So we can say that this guy is a public figure. Okay. And the defendant is one of the newspaper owner, Khom Chatlyk. Okay. The owner and the editor has been sued by the plaintiff, a politician, based on the invasion of the right to privacy. So this is the fact. Back in July 2003, there had been photo of two persons having sexual intercourse, sexual activity, published in several newspapers and other media channels. However, the photo was blurred, right? But the defendant, this newspaper had being sued in this case, the defendant published that photo with a content asserting one of them was the plaintiff. So the name of the plaintiff has been mentioned, right? So in this newspaper, they say that, okay, in this blur photo, the male in this photo is the plaintiff. The name of the plaintiff has been mentioned, has been addressed in the article. Okay. After that, the plaintiff came to the court and sued against the newspaper. So the defendant claimed that its publication was to fulfill the duty of the media, right? All the time, the media who fight in the case like this, they're gonna raise the public interest defense all the time. That, okay, the public the subject matter that they publish is related to public figure, and it's kind of like related to official position of that person, right? But in this case, the defendant raises so many arguments. Okay. The content in this issue was obtained with the defendant's consent. They made an argument that the defendant has given consent already. But this is just the argument, the argument made by the defendant, not the result of the case, okay? So, the content in issue was obtained with the defendant consent, as the defendant had made the request to the police to prosecute the person who aimed to injure the defendant's reputation. The publication would be beneficial and serve public interest because the content would let the readers know what happened, how the plaintiff was defamed by his ex-wife. The public would be able to understand how credible the plaintiff was, But the court said that this argument was not valid. The fact that two persons having intimate activity in private place what human nature, the person has the right to privacy, which has been recognized by the Constitution over such activity. Even though the defendant enjoy the freedom of expression, freedom of press, but it didn't mean that the defendant would be able to invade others' people's right to privacy. Now the court was conducting the assessment. See, the content published by the defendant was similar to other sources, but the other sources did not identify who that person is. Okay, the act where the defendant made the public aware that the person was the plaintiff constituted a privacy invasion, which was a wrongful act according to Section 420 of the Civil Commercial Code. Right, claim. Defendant also claimed that the plaintiff has already reviewed himself disclosed to the police, but it doesn't mean the court said the plaintiff must do that because the requirement of the criminal procedure law to ask police to proceed. The disclosure to police is not equivalent to the consent for other people to make it public. Different. The court also refused this kind of argument as well. The defense also claimed that the plaintiff was a public figure, so to do the publication with his affair is okay. The court also denied this argument. This is really important. The court said being a public figure does not totally sacrifice one's privacy. You learn from this that, okay, public figure must sacrifice a part of their lives, right? However, being a public figure does not totally sacrifice one's privacy. To some extent, the plaintiff enjoyed the right to privacy. The news content regarding the matter, which was genuinely private, and the disclosure of such facts would not be beneficial to serve public interest, but instead merely cause harm to the plaintiffs. So, the plaintiffs will be winning in this case. So the defendant claimed that the publication would benefit the plaintiff was not valid. No reasonable person would give consent to allow the defendant to do so. Okay. So in this case, the politician won, right? The court believes that it's not worthy if we say in other words. Okay. So there are something which is interesting questions. What if the new paper did not identify the name of the plaintiff? That would be different, right? The result of the case. If the newspaper used the initial, like Mr. A, will not change. Will it change the result of the case? What if the content concern other activities of plaintiff is okay? Because now it's just the activity that they have in really like intimate area, right? What if the content also contains statement contrary to the truth that would lead to defamation? So this is a really concise overview on the conflict of freedom, privacy. Oh no, freedom of the press and privacy. And there are more cases related to this matter. And I already assigned this to you guys. And when the presentations on these topics come up, we're gonna have further discussion on this. So the meta class, the clip video on media freedom and privacy will be added here. Okay, there are totally 2 clips, and then I hope you enjoy it, and we'll see you in the presentation weeks. Thank you very much. Bye bye.